Well, welcome everyone. Happy Monday. Hi, Jennifer. um, I'm very pleased to welcome to our group Jeff Tenenbaum, who was with us. I was surprised it was so long ago, July, and answered some great questions and followed up with some really nice template speaker agreements and so on that I've used. I know others of you have used them. And he's gracious enough to join us again to take our questions. Jeff, we won't go through introducing everyone, but this is representative of anywhere from Washington to Florida, Michigan. You have a nice mixture of CEs here, chapter execs. Connecticut has joined. So I'll start out with the first question, if I may, Jeff.
Sure.
Okay. Should we be recording board and committee meetings?
As a general proposition, I am not a fan of recording.
Why is it that I'm not hearing this?
Oops, hold on. Simon, I'm going to mute you. Okay, go ahead, Jeff. Sorry.
Okay. Generally speaking, I am not a fan of recording board or committee meetings, and it's generally not a best practice. For one, meeting minutes, which should be taken at board and committee meetings, should generally be a reflection of actions taken at the meeting, not of all of the discussion that occurred. So for instance, minutes might say the board discussed, the potential cancellation of its July 2021 annual in-person meeting or something like that, and then came to the following decision or approved the following resolution or something like that. It should not have some sort of a detailed back and forth. This person said this and this person said that. And I say generally because there can be a few exceptions. Like if there's ever a dissenting vote or an abstention because a board member, committee member disagrees with that, generally it's a best practice to record that in the minutes. But other than that, or maybe also if there are two like competing factions on an issue, you might say the board discussed XYZ. One faction of the board supported doing this, another faction supported doing this, and here's what they decided. So it should be, to the point, focused on the actions and the outcome, with, very brief, minimal, high-level description of what was discussed in like a sentence or two, if that. And sometimes you don't even have to do that. Recording is a whole different ballgame because then everything is there for purposes of a written record, which can be discoverable in litigation. In investigations and enforcement actions, in private litigation, makes you much more of a potential target. And frankly, it just opens you up to all sorts of legal and other risks, political risks, financial risks, business risks, that really are not necessary. Now, I have had some clients over the years that are very big on keeping very detailed minutes, even more detailed than I prefer. And they say that they record the say board meetings, but only for the purpose of the secretary who is acting on the secretary's behalf to be able to record the minutes, and then they're immediately deleted. If you insist on doing that, or if you feel like you have to do that, that would be the farthest I would be willing to go in terms of, if you're asking for my opinion on doing so. But I would much prefer not to have that exist in the first place. Too much of a chance of something not being deleted, or how things work these days. You think something's deleted, but it's actually not fully deleted. And having been through so much discovery through investigations and litigation and things like that, it's amazing what these IT firms that they bring in can pull off of your servers, from deleted files and whatnot. So my strong recommendation would be against any recording of board and committee meeting minutes.
And your response brings to mind another question. I was always told that one should not say a specific name. So-and-so made a motion. It was seconded by so-and-so. You just say it was moved and seconded. Is that?
That's exactly right. You do not have to note the specific people. And so many associations still do that. And there's nothing wrong with it. It's just unnecessary. It's necessary to have a motion made in a second, but not to record who made the motion and who made the second.
Interesting. Okay.
Do keep in mind as basic parliamentary procedure that the chair cannot make motions. The chair can ask for a motion, but I see that mistake a lot, that sometimes the chair will make a motion and that can't happen.
Very good. Other questions from the group? Mary, are you trying to embark on a question? You're muted though.
Sorry, I hate to put him on the spot. I thought Simon
I
had a
had
question.
my
Didn't I
hand
see a
up,
hand
but
up? I'm
Jeff
unmuted.
answered it as
Yes,
a follow-up.
Alan.
I tend to take detailed notes. I don't usually record it, but I take detailed notes so I know what it is everything was talked about. After 30 years, I'm still learning how to abbreviate the minutes down to, what happened.
Yeah.
But I just find that without having those detailed notes, I couldn't do it. But I totally understand about the recording. Is there any way to record a meeting without everybody else knowing you recorded it?
Not advisable because many states have laws that do not permit recordings with just one party consent, meaning a lot of states require both parties, or all the parties to consent for a recording if you're gonna make a recording of their words or their images. First off, on things like Zoom, you see in the top left-hand corner it says recording, so you can't hide it in a Zoom call. But for audio meetings or for audio recordings, highly advised against doing them without anyone's permission. And then frankly, for the reasons I already explained, highly advised against doing it generally. And Alan, if you feel like you want to take detailed notes in order to then put together the minutes later, I think that's fine, but those notes should be destroyed after you're finished.
You got it.
Yeah. And remember also, minutes don't actually become minutes until they are approved by the board or the committee, usually at the next meeting. I mean, it can be done, by unanimous written consent in other ways, but typically it's just done at the next meeting.
Alice, I have a question. If a board goes into executive session, is the discussion from that executive session undiscoverable, confidential, and does it remain so?
First off, great question. I get questions around executive sessions all the time. Let me first give you a little more context before I answer that specific question. Executive session is used, I find, by different associations in different ways. Generally, what it means is, if it's a, say, meeting of the board, it means board members only. Oftentimes, along with perhaps legal counsel, if you happen to have legal counsel at that meeting. Legal counsel is often involved in executive session, but generally it means board members only. Sometimes, though, it can also mean, like, if you're, I guess you guys are mainly the executive directors of your various chapters and whatnot. Oftentimes, the chief staff executive, the executive director, the CEO, is a member of the board as well. But sometimes the board will go into executive session for the purpose of evaluating the performance of and setting the compensation of the executive director. That's referred to executive session as well. And frankly, anytime that, whether it's the executive director or a board member, say, has a conflict of interest, then the board may go into executive session to discuss that conflict and how to manage and resolve it. And they will ask that board member with a conflict to not participate in that. That would be considered executive session as well. But it generally means no other staff, no other outside guests, things like that you might otherwise have at a meeting. Now, all of that being said, one question I get asked a lot, and it's not your question, but it's a relevant one, is should we take meeting minutes of executive session portion of our meetings? And the short answer is yes, you need to. Now, oftentimes they're much more bare bones, but if important decisions are getting made in executive session, they need to be recorded. There needs to be minutes of that. Now, you might store those minutes in a different place than you do, the rest of the board meeting minutes and whatnot. And different associations deal with that differently. Some use legal counsel to store those. Some, I'm not even sure how some do it, because it's a really kind of dangerous practice to have, like, the then volunteer president, keep a record of his meeting minutes, because, as you know, those people turn over and they're not going to be a part of your organization in a few years. So that's kind of a dangerous thing. But sometimes there'll be like a trusted, COO, head of HR, something like that, who might be the keeper of those minutes. But you should have some sort of record of not the discussion, but at least the decisions made in executive session. Now, to your question about are they discoverable in the event of either private litigation or a governmental investigation or enforcement action or governmental litigation, wherever there's subpoena power and ability to discover things. The short answer is yes, all of those are going to be discoverable, whether it's an executive session or regular session, unless it's protected by one of the privileges And generally, the only privilege that typically applies in the association context is the attorney-client privilege. So, and what the attorney-client privilege means is that the communications involve an attorney, and that attorney is giving legal advice to that body. So it means a few things. Attorneys involved, communications involve legal advice, not just business advice. Because sometimes you have the attorney that's really acting just as a counseling on business matters, not giving legal advice. The first article I actually ever wrote, I was still in law school, I think, and was working at ASAE during the day, and I wrote this article in part for law school called like the attorney-client privilege and how it applies in the in-house context for in-house lawyers. Like ACC, the national group, has a number of in-house lawyers, most of whom I actually used to work with. They were colleagues of mine at Venable. You have a great team of lawyers there. A lot of times in-house lawyers are giving legal advice, but sometimes they're serving in a business capacity as well, kind of giving business advice. And there's a whole line of cases, including U.S. Supreme Court cases, that make clear that just because it's an attorney there, an attorney is giving advice to the organization, doesn't automatically mean it's covered by the attorney-client privilege. And if someone wanted to challenge that privilege, say someone, a plaintiff in a litigation is subpoenaing, meeting minutes, and the organization says, no, our attorney was present, it's covered by privilege. Someone wanted to push back on that and try to pierce that veil and pierce that privilege. They might argue that the person was only giving business advice, not legal advice. So keep that in mind, legal advice by an attorney. And then this is really important. In order for the privilege to apply, there cannot be any third parties present in that communication, whether it's in person, on the phone, on the video, or on the email exchange, whatever it is, means only the party. So the party itself, which is your organization, your chapter, basically means the case law refers to as like a control group. It's basically your board members, officers, directors, sometimes committee members, and generally like senior staff of the organization. Those are all going to be covered by the privilege, and of course your legal counsel. But outside of that, any guests, any third parties, or any like former board members who might be attending the board meeting, your outside experts like accountants or investment folks or insurance folks, unless, in some exceptions like involving litigation, those folks will be retained by an attorney, and that can be covered by the privilege. But generally speaking, anyone who's not officers, directors, or senior staff, or sometimes committee members, is not going to be covered by the privilege. So if you want to get the protection of the privilege, again, whether it's an executive session, regular session, even just an email exchange amongst the board, you want to always be sure there's no third parties involved. And then another thing you should do is always kind of label it as privilege. Sometimes you put at the top of a document or an email exchange, confidential, subject to attorney-client privilege, things like that. That doesn't turn something that's otherwise not privileged into a privileged document or communication, but it certainly helps, and it certainly helps flag it in the event. And it's going to be helpful if you ever got challenged on it later. You're trying to assert the privilege and someone's trying to challenge you on it. It's not a bad idea to do that. And of course, the last thing is, I deal with this all the time. You want to remind board members of their duty of confidentiality, and committee members and others. It's inherent in their fiduciary duties. It's part of the fiduciary duty of loyalty that includes the duty of confidentiality. But it's not a bad idea to remind them of that, both verbally or in an email exchange, particularly when you're talking about sensitive information. Say you're talking about, an issue with an employee and you might be wanting to terminate them, or you're dealing with an issue with a board member that has a big conflict of interest or engaged in some problematic conduct or other things like that. And you're talking about sensitive things that could hurt their reputation or whatnot, basically giving rise to claims like for defamation and tortious interference or antitrust claims or things like that. You want to make sure you have the benefit of the privilege, because if anyone came back and sued you for that, you want to be sure that those sensitive communications are protected. So reminding everyone of their duty of confidentiality, both in the moment, as well as by having, it's a best practice to have some sort of written confidentiality policy and statement, that they affirm. I actually worked on one over the weekend that I'm happy to share with you. In fact, I'll share it with you, Alex, and you can share it with the group. Basically like a one-page form that you can have board members and committee members sign every year. Very simple. That basically, I think it has 4 parts. I modified it to add an antitrust provision to it because the issue I was dealing with for a client involved antitrust issues. But it reminds them of their duty of confidentiality, It reminds them of their duty to avoid conflicts of interest that are harmful to the organization and to comply with the organization's conflict of interest policy. It has a copyright assignment provision. Basically, because they're non-employees, any contributions that they make to like written work product, a new program you're developing, other things like that, you want to be sure the intellectual property rights, especially the copyrights, are assigned to the chapter. And so having that form is helpful in that regard. And then the fourth is kind of an obligation to comply with the antitrust laws, to not discuss amongst themselves, like amongst board members, fees, prices, things like that, other things that can be anti-competitive, give rise to antitrust violations. So it's not a bad idea to have them sign that every year. Now that's generally, you could be done in conjunction with, but also it's a very much a best practice, and we're getting into other areas, but to have a conflict of interest policy, and then also to have your board members and often committee members sign that conflict of interest policy, A, to affirm their adherence to it, but B, to disclose any conflicts of interest that they may have. They obviously have an obligation to do it on an ongoing basis as they might arise during the year, but it's generally a best practice to do that. So I will send, I'll send you both a sample conflict of interest policy and disclosure form and that other, kind of shorter form that I mentioned. It's really not a bad idea to do this for not only the legal rights that it will impart to your chapter through that form, but also to remind them of their duties.
A question on the confidentiality. So there's been issues of late with members, even leaders, sharing the chapter logo when not authorized to. So would your confidentiality statement cover that situation? Because they're not supposed to do that.
Probably not in the way it's written, but it could. I mean, first off, so what you're talking about is not just sharing. I mean, the logo itself is not confidential, right? It's probably on your chapter's website. Right. It's more providing it to someone with some sort of an express or implied license to use it in some way that they should not be doing, right? And that is, actually, I do have I'll send you, I don't know if it's really applicable. But basically, and this is really important, there's a 1985 U.S. Supreme Court case called American Society of Mechanical Engineers versus Hydro Level. It was an antitrust case involving some bad actors who engaged in some standard setting to benefit their own company. Don't worry about that part of it, but the important principle here is that it ensconced in the law this concept of apparent authority, meaning that if someone acting on behalf of your organization, in this case, I think it was the vice chair of a standard setting committee, but if someone is acting seemingly on behalf of your chapter and has to the other party, it would be reasonable for them to believe that the person has authority, for instance, in this case, to grant a license to use your logo, like a board member, for instance, right? If a board member says, here is a copy of our logo, you can put it on your website, you can, call yourself an endorsed vendor of our association, you can, do whatever it might be. That person, that board member probably has the apparent authority to do that, even though they don't have the actual authority. And what the court said was that in that situation, the association is going to be bound by that action. It's going to be on the hook for what happened, even if in fact that person did not have authority. And so what it said is it's a lesson for associations and others to make sure they police the use of their intellectual property and things like that. And there it had to do with like things like letterhead stationery and things like that back in the day. But basically make sure that those who actually don't have authority to do things could be signing contracts on behalf of your association for a meeting or an event and all sorts of other things. You want to make sure that they're not acting when they don't. So I actually think I have a parent authority policy. I'll have to see. I worked on something last year for a client that I might be able to adapt, and let me see if I have that. I'll send that to you. But regardless, you could actually add a sentence, provision to that one-page form, as well, talking about, basically, I would make it broader than just trademark licensing. I would say, a reminder as a board member, don't ever act on behalf of the chapter unless you in fact have the authority to do so.
I think having them sign something like that, even just to raise the awareness of the issue with a new board member, would be a good idea.
Yeah, I may add that to the form. I think it would be a good addition generally, and then I'll send
Hey,
it.
Alice, I have a follow-up to my original question.
Okay.
Jeff, does our new world of Zoom and electronic meeting change the parameters of executive session? And if so, what are the cautions that we need to exercise?
It really doesn't. It doesn't really change anything. You know, in terms of the basic construct, the basic legal principles, it's still going to be the same. Like what I just talked to you about, attorney-client privilege, things like that. It's all going to be the same. And I think what's different is that by the host clicking one button, you can record a meeting much easier, and that recording, if it contains sensitive, problematic information, could be easily accidentally, used in particular purposes or leaked or other things like that. That's one thing. The second thing is, and one thing that's good about things like Zoom is, it's impossible to have someone on the call without you knowing that they're on the call, right? I mean, anyone can put any name on their box or things like that. But certainly, if there's video, or if, you can see anyone that's either logged in on a computer or calling in on their phone. So that's a helpful thing, as opposed to like back in the day when it was just audio calls for meetings like that. It was very difficult to ascertain who's actually on the call. But so the basic principles though are still really the same. And this kind of goes beyond your question, but one of the articles I wrote last year during the pandemic was about legal governance challenges for associations during the pandemic, and what talked about a number of different issues, but a lot of them related to membership meetings of associations, and kind of not just membership meetings, but how members can act outside of a meeting. Because in the past, a lot of associations would hold an annual meeting of their membership in person to do things like elect the officers and directors and things like that. And all of a sudden last year, when no one was having in-person gatherings of members, questions arose. Well, how can we elect our officers and directors if we used to do it? Can we hold a virtual meeting instead of an in-person meeting? Does it have the same legal effect? Can we take a vote using some electronic, voting mechanism as opposed to having an in-person meeting? And the short answer is it depends on your state of incorporation, where your nonprofit is incorporated, because every state has a nonprofit corporation statute, and that statute regulates those sorts of things. Some are stricter than others. For instance, some say you can have like virtual meetings of the membership, but only if it's authorized in your articles of incorporation or your bylaws. There is actually a couple that say you can only do it if it's authorized in your articles of incorporation. So you look to the state statute, then you also obviously look to your articles of incorporation and your bylaws to see what it provides and what it allows. And this is an important kind of lesson or reminder to keep in mind that when you're thinking about governance and actions of the organization, I tend to try to divide it up in 4 different buckets. 2 overarching buckets. One is board action and one is membership action, right? In a nonprofit corporation, all power, all authority defaults to the board, except whatever authority is given to the members through statute, like the nonprofit corporation statute, or by your articles of incorporation and your bylaws. So by statute, for instance, almost every state says that if you have voting members, which I think you guys all do, only voting members can approve a merger, consolidation, a dissolution, or a transfer of substantially all of the assets of the organization. It requires member approval. Most also say that amendments to the Articles of Incorporation would require a member vote. Beyond that, by law, in most states, there's nothing else that defaults to the members. A few states say, like, if the members elect an officer or director, only those members who elect, only that group of members that elected them has the right to remove them from office. A few say that. But beyond that, most of the other powers default to the board, unless your bylaws, for instance, give authority to the members, like it's often the case, the authority to elect officers and directors and or remove officers and directors. So that authority is given to the members. The rest defaults to the board. So you got board action, you have membership action. For each one of those, I tend to think of it, I think it's helpful to subdivide it between action at a meeting and action outside of a meeting. So there's basically 4 different constructs: board action in a meeting, outside of a meeting, member action in a meeting, and outside of a meeting. And you have to analyze each one differently because the legal construct is different for each, depending on your state of incorporation and depending on what's in your articles and your bylaws. So I will tell you, for most states, and there are definitely differences, and I'm familiar with most of the state statutes in this regard. For most states, board action at a meeting says that as long as you have a quorum participating in the meeting, whether in person or virtually, like audio or video, it basically says as long as everyone can simultaneously hear each other, because most of these statutory provisions were written before Zoom meetings and things like that. But they say as long as everyone can simultaneously hear each other, then as long as you have a quorum, however you define a quorum of board members, then it just takes a majority of those voting, majority of a quorum, to take an action at a meeting. Could be all virtual, could be in person, could be combination, doesn't matter. So you just need a majority of a quorum, unless your bylaws impose some sort of a supermajority, like 2/3 or. Then also keep in mind, there's a difference between a majority of a quorum and a majority of all board members. And a lot of bylaws that my colleague and I review are deficient in that they're not clear what the standard is, whether the approval threshold is a majority of a quorum, a majority of all board members. It's different. And if you have a larger board, that can make a big difference. So that's one thing to keep in mind. That's board action at a meeting. Board action outside of a meeting, in most states, not all, there's a few exceptions like Texas, but in most states, the law says that the only way a board can take action outside of a meeting is through what's called unanimous written consent, which means all board members are voting in writing and they're all voting the same way. It can be electronic in most states, but it's actually not called a vote, it's called unanimous written consent. And that's the only way that a board can take action outside of a meeting. Now, a board could do something like take the sense of the board, take a poll, whatever, and decide to move forward with some action based on that, and then have the board ratify it at the subsequent meeting of the board. But if you want to have a true legal action of the board outside of a meeting, it's got to constitute unanimous written consent. For member actions, both in a meeting and outside of a meeting, the laws in most states are much more flexible, because members don't owe fiduciary duties to the organization. And as such, most states allow for members to vote like electronically without it having to be unanimous written consent. So for member actions, let's take at a meeting. Most states, not all, but most states will say that members can take action at a meeting, kind of the same basic construct, either in person, virtually, combination, and as long as you have a quorum, then a majority of a quorum is going to carry the day, unless there's some sort of supermajority involved. But you do need to look carefully at the state statutes, because there are some differences. And to get even more complicated, like New York the governor issued an emergency order, I think early to mid last year during the pandemic, to say that member meetings could be held virtually, but it's not actually authorized in the statute. We don't know whether that's going to go away after the pandemic or whatnot. For member action outside of a meeting, most state statutes allow member action like an email vote or an election. Usually you don't use email these days, you use one of these electronic voting platforms. It's much more safe and secure and efficient. And most states do allow members to take action outside of a meeting. And usually what it says is that as long as you have enough people voting to constitute what would be a quorum, then a majority of those voting is going to carry the day. Again, unless your own governing documents have some higher threshold or whatnot.
Jeff, can I ask you a question about that really quickly? I actually joined, personally, I joined a board of directors in the state of Florida this past year because everything's on Zoom, and I was finally able to. My question for you is, because now that I'm in a leadership position on this board, I would like to stay on it. Is there any sort of, I think I know what your answer is going to be, but is there any sort of way, if it's not in our bylaws and it's not in our articles of incorporation, but we all just kind of agreed we're going to do Zoom meetings this past year, to continue that? Or is that something that we need to vote? We need to get the members together to vote and change our articles of incorporation or our bylaws? Or can we just sort of continue doing it because we were doing it and that was sort of, I don't know what the word is I'm looking for.
No, it all depends. I mean, it's a good, just for like a CAE prep session, it would be a good test question. Basically, you're going to have to look, just what I said, to the statute, to the articles and the bylaws to see what they permit. In most states, holding a Zoom meeting has the same legal effect as an in-person meeting. So most states, again, not all, but most would allow you to have complete virtual meetings and never have an in-person meeting. That should be sufficient. And the whole idea behind, meeting requirements is so that the members of the board, for instance, have the opportunity to debate, discuss, and deliberate issues. And you can do that over Zoom as effectively, as we've all learned this year, in the last year, as you can in person. And so, yeah, if the statute allows it, and now if the statute says it has to be pre-authorized in your articles or bylaws, then that's a different issue. You have to look and see. But if it just says it's permissible, then you don't, and which most states that's what it says, then you don't have to have anything in your articles and bylaws. You don't have to have your members vote to do so. And in most states, I'd say that's going to be likely be permissible. I don't remember if they're incorporated in Florida. I don't remember what the Florida statute says off the top of my head. But that's what I would check. And it's very easy to check. You can find all these statutes online. Just do a Google search, Florida Nonprofit Corporation Act. Usually comes up with an index of the different sections. Whether you're looking at the board section or the membership section, click on that section and scroll down to meetings or action without a meeting. And, can get a little bit confusing, but it should be pretty easy for you guys to check that.
And I have another question, but I know Alan's had a question for a while. So Alan, do you want to go first?
No, you have the floor because your hand was up before mine, so go.
So my other question, this is more management advice I'm asking for. I have a new president coming in, and I won't name him, but every time we have a meeting, whether it's a committee meeting or a subcommittee meeting, he always Mary, can you take the minutes? Or Mary, send us the minutes. And I want to stress to him that let's just call them notes, let's not go formal. Is there any sort of, you were talking about discoverable earlier. Is there any sort of advice that you could give to me that I could convey to him that we don't need minutes for this call that had 3 people on it that was 15 minutes long just to chat about something? Again, not asking from a legal standpoint, but it's kind of making me a little crazy. And I don't think he really understands minutes have to be approved. And there's a whole bunch of extra steps involved when you start calling it minutes.
All right, a few thoughts. First, and I think this is more of a non-legal issue than a legal issue, but I'll opine on both aspects. From a legal perspective, the term minutes generally only means the record of actions at an actual meeting, like a formal legal meeting of the board or a committee. If it's just a group of 3 officers or 3 directors or a couple staff, like a task force, whatever else, probably is not going to be a true legal meeting, where you have notice given and all the other stuff is provided by your bylaws. So probably I would not use the term minutes to apply to that, just because it probably technically doesn't apply. From a practical perspective, I'm not sure it really matters. All of this is discoverable. If you're talking about legal risk, not that there's going to be a lot of legal risk from most of these sorts of calls and meetings, but if you're asking about legal risk, it's all discoverable unless it's protected by the attorney-client privilege. So that part I wouldn't worry about. To me, this is just more of an overall efficiency issue and how much time is a waste? Is it a waste of time or not? How much is it taking away from time that you could spend on other things? I have later today, I think a governance task force call for a client of mine that every single meeting we have of this governance task force, one of the staff members of the organization takes detailed notes or minutes, whatever you want to call them. It doesn't really matter. And they circulate them because the task force felt it's important to have a record of everything that we're deliberating, because in the end, they're going to come up with some big recommendations to overhaul the entire governance structure, the worldwide governance structure of the organization. So sometimes there are some really important reasons for doing so. So it's hard to generalize. I'm not saying you should never take notes of every call, but to me, it's more just a balancing of the cost benefit analysis. And yeah, and look, whether you got a chair or president or whatever who's pushing you around or whatnot, this is a common problem for staff of associations. It's been that way for the 25 years that I've been doing this. Some are better or worse than others, in this regard. You need to try to strike the right balance, of course.
Thank you.
Sure.
Alan, and then I have a question that Sherry sent in advance too.
Okay, quick question. So ACC is its own corporation, and we are all incorporated too. Our bylaws, though, in many cases are tied to rules from the ACC. So when the Board of Trustees approves a new set of bylaws or a change, it causes ours to be perhaps somewhat obsolete. Is there a template phrase that we could add to ours the next time we pass our bylaws that then would kind of prevent ours from being obsolete when the ACC adds a new membership category, for example?
Sure. Yeah, I don't think I've ever looked at any of your chapter bylaws. I don't know if I've looked at nationals either, but yeah, you could have a provision that says that, basically anytime there's a change to ACC's bylaws that have an effect on chapter bylaws, those changes will be deemed to be effectuated in our bylaws. Something as simple
That's exactly
as that.
what we did, Alan.
Did
Same
you?
thing.
Okay. I'd like
Yeah,
to get that from you, Mary.
From an efficiency perspective, that would seem to make sense.
Yeah.
Okay, and Sherry asks, kind of really changing our course here on questions. Can an organization require attendees at a conference to be vaccinated? She's heard different opinions on that.
Yeah, so I get this question quite a bit. I think our last call, I can't believe it was last July, you said, but the last call, I know we spent a lot of time, I think, talking about association meeting, contract and cancellation and related issues. Now fast forward to mid to late February of the next year, and now we're talking about, we're still talking about some of the same issues. I'm almost every day having conversations with clients about meeting cancellations for 2021, postponements. But a number are also starting to plan ahead for in-person conferences, especially in the second half of this year, and how to go ahead and do it safely. First off, I'm going to send you guys a link to an article that I wrote after I talked to you guys last time about something. It's all about like the top 10 legal considerations for in-person meetings or something along those lines. And I'll send a link to you guys. I think that'll be very helpful to you. And even though it was written probably 5-6 months ago at this point, it's still very relevant and timely in terms of the kinds of thinking you should be going through when you're potentially planning in-person meetings. One of the questions that we're getting now that vaccines are online and available, obviously not to everyone or even close to everyone. By the way, this is kind of a moot point unless and until we get to the point that everyone who wants a vaccine can get one. And I don't think anyone really expects that to be before the summer. But there will come a point, say in the fall or later next year, when everyone that wants to get a vaccine can get one and get the full dosage of it and have enough time pass afterward. And so then the question arises, can we require proof of vaccination? I saw a story yesterday about how Israel, which is further ahead in the vaccination process than any other country, has this app that they created. They have kind of a national health system, kind of like in the UK. So it makes it easier to centralize it, but they have this app and it's called a green card or green pass or something like that. And if you get vaccinated, you have this app and you basically show it on your phone, that you have proof that you were vaccinated. And they are going to require that in order to get into things like restaurants and concert venues and sporting events and things like that. Now that's a government entity requiring that. And if the government, requires something like that, which is highly unlikely to happen ever here, I don't think it could happen constitutionally at the federal level, but at the state and local level, it may or may not happen for certain types of events in certain cities and states. We'll have to see. But here the question is, can a private organization like an association require proof of vaccination before attending your conferences? It's a tricky issue. One thing I want to point out is that the answer to that question is going to be different when you're talking about employees versus members and conference attendees. It's going to be a different analysis because employees are subject to greater protections under the law than members are. All sorts of anti-discrimination laws in terms of medical information, in terms of disability, in terms of religious protections. There's so many other protections in the law at the federal and state level that apply to employees. Discrimination against genetic issues. There's all these different laws that can apply in the context of employment that don't apply to members. So in the employment context, you have to be much more careful and very deliberate in how you go about issues like this. If, for instance, you're going to require proof of vaccination before returning to your in-person offices. And I think the general thinking right now, and this might change because there might be federal laws that get passed, that provide some protections, that change the rules, that provide exemptions, things like that. But right now, the current thinking on the employment side is that if someone says that they do not either feel, for religious reasons, for health reasons, for whatever else, that they can't get vaccinated, they don't feel comfortable getting vaccinated, that you cannot effectively fire them from their job or make it impossible for them to do their job, that you do need to likely make a reasonable accommodation so long as they can still perform the essential functions of their job with that accommodation. And the easiest accommodation is going to be remote work. And in most associations, most jobs can be done, as we've seen over the last year, pretty effectively remotely to the same they can in person. And as long as that's the case for that type of job, it's not going to be the case for every association job, but for most it will be. And as long as you can make that accommodation, you probably need to. In the membership meeting arena, it's different because members and other attendees don't have some inherent right to attend a private association's conference. Is it valuable and beneficial? Of course it is, or you wouldn't be doing it. But it's not, for instance, from an antitrust perspective, it's not essential in order to effectively compete in your profession. It's helpful, but it's not essential. It's not essential in order to practice cardiology. It's not like getting a license or something like that. And so the construct is just very different. And what that means is that it gives you a lot more leeway that if you do want to require, this is again, once we get to a point that everyone who can get one does get one. Legally right now, again, the thinking is still evolving, and I've read some articles that some other folks, the ASAE published an article about this just a week or two ago about vaccinations, and it flagged a lot of the issues. It really didn't have as many answers as it did raise questions because we still have all these open questions. But I think generally speaking, if you wanted to require proof of vaccination before attending an in-person conference, with the one exception possibly being the Americans with Disabilities Act, which does apply to in-person meetings and things like that. And that poses a little bit of a wrinkle, but that law aside, you probably could require it. And even if someone challenged you and said, well, look, I have a religious opposition to vaccines, or I have a health condition that it's too risky for me to get a vaccine and my doctor says I shouldn't, it's hard to think of a compelling legal claim that someone could bring against the association as to why being denied physical access to your conference, created some legal right on their part. Now, do you want to have to deal with those issues? Do you think it's bad PR? Other things like that. Those are different but very important considerations. What I've generally told to association clients of mine who have asked that question is, if you are planning on going that route, doesn't mean you necessarily have to hold a hybrid, like an in-person and virtual conference at the same time, or the virtual conference, a week or two later, using some of their same content from the in-person conference. Although many associations are planning to do that in 2021, because they know they are still going to have a lot of folks who are not going to be willing to attend in-person meetings. So they're trying to maximize revenues and attendance by having some sort of a hybrid option. And if you do, obviously that kind of solves that issue, at least for 2021. We'll have to see what happens in 2022. But as long as you're making, the core of that educational content available to folks who want it and are willing maybe to pay for it, then I think it really even further helps to reduce your legal risk if you wanted to require vaccinations for in-person attendance. And then one other thing, the article that I'm going to send you points out, liability waivers, releases, generally a good idea for conference attendees to have them sign. And I have a link to an article of mine that has a model kind of liability waiver and release for attendees to say, look, I'm attending this conference knowing that there's the risk of contracting COVID, and I'm going in assuming that risk and with my eyes wide open, and I agree to hold the chapter harmless from any liabilities that might result if I were to contract the virus in connection with your meeting. And then the form also has a second section that talks about kind of I attendee agree to do the following, like to follow all rules that the chapter imposes in terms of mask wearing and social distancing, to not attend if I'm, have a fever or otherwise feel ill, to not go off site and engage in risky conduct and then come back and potentially infect the rest of the crowd. Things like that, those sort of conduct prohibitions. It's helpful to have that stuff in there. So I included that in the model release too.
So gone are the days of saying, hey, we're having a reception, come on over.
Well, this year is not going to be that simple. Hopefully by next year, we're a lot closer to that again.
Is that something we can just add to like our registration link? I mean, I'm also trying to limit how much paperwork we're handling
Yeah,
on
no,
the
it doesn't
site.
have to be,
Okay.
most are not using actual paper to do this. It's like a click and accept form. Yeah, you can make it as part of that, but like any liability waiver, you want to make sure there's an affirmative kind of click and accept on the part of the attendee. Don't just bury it in there and say, by registering, you agree to the following terms and conditions. If you want to have it, liability waivers can and are challenged all the time in court, sometimes successfully. One of the ways to help mitigate that risk is to ensure that they were fully aware of what they saw and that they affirmatively, clicked and accepted, they agreed to it.
Going back to the minutes for just a quick moment, can meeting minutes be shared with members outside of the committee or the organization for which it's written? So if ACC wants a chapter's minutes, or a chapter wants ACC minutes, or the lumbermen in Michigan want my minutes, how guarded are they?
Yeah, so generally speaking, unless, now, for instance, if there's something contractually, like I think you guys have a chapter affiliation agreement with the National Association. Like if your chapter affiliation agreement, had a provision in there that said, the chapter agrees to share its board meeting minutes, with national, every quarter, once a year, whatever the case might be, then you have a contractual obligation to do so, for sure. Outside of a contractual obligation, there's generally no right, or no obligation of an association board, for instance, to share its minutes publicly, with the exception that, again, you got to go to the state nonprofit corporation statute. Many state statutes do provide rights to board members and even to members to inspect, usually refers to as inspection of certain documents of the association. And in some states, members, like voting members, do have a right to inspect the meeting minutes, like board meeting minutes of an association. So it doesn't mean you have an obligation to publish them or to put them on your website, and most associations don't, and I don't recommend doing so. But keep in mind, under the state statutes, voting members sometimes do have rights, and oftentimes they don't even have to have a particular purpose. It's just a pretty broad right if they ask for them to provide them. Now, of course, all of that, keep in mind the attorney-client privilege issues I raised. If any portion of meeting minutes are privileged, then you absolutely want to make sure you're not sharing them with anyone else, or you would defeat, you would lose the privilege in the event that you did that.
Well, this is so very, very valuable. And I really appreciate your sending all of those follow-up documents and links.
I will do that. I have a nonstop crazy day, but I will get to it tonight probably, and I'll send it to you guys. And I want to revise that board and committee form, because I think it would be, I'm going to add that provision about kind of apparent authority to it, which I think will be a helpful addition.
Great.
Jeff, one thing I'm not clear on is where I'm going to find the liability waiver. You mentioned it being somewhere, but I'm.
So first off, when you see the link, it's to an article on our website. We have a ton of articles and other materials on our firm's website. A ton of probably about 75 different articles and tons of recorded webinars on all different topics. You can find all that stuff there. That being said, there's a lot there and it's hard to navigate. The article I'm going to send you about the top 10, meeting legal risks or something like that. One of those top 10s is about liability waivers, and it has a link within the article to that model liability waiver of ours. So you will find it there.
Okay, thank you.
Okay, and Jeff, I'm going to thank you again and say, if you're open to another invitation, we will extend it.
No, I really enjoy speaking to this group, and yeah, if you just want to ping me every how many months, every 6 months or so.
Yeah. Yeah. Okay. Thank you so very much. Appreciate it.
Have a good day.
You too. Okay, everybody.